The General Data Protection Regulation, GDPR, was established in May 2016. It comes into legal effect on the 25th of May 2018. It applies to all organizations in the EU and all organizations outside that are active in the EU. If you use personal data, you are considered to be a data controller under the terms of the GDPR, which carries a number of obligations. And unless you already have a comprehensive and effective data privacy regime in place, GDPR compliance is likely to be a challenge. It will need top management attention, dedicated planning and implementation resource, financial support, and significant cultural change. But before you can make progress on compliance, you need to know where to start. This involves knowing what personal data you collect, how it is stored, processed, and secured. In each case of personal data usage, you must understand the legal basis for the data you are holding and if consent is required. If you use cookies to collect data or they are used on your behalf by a third party, such as Google, you must ensure that where consent is needed, it can be withdrawn just as easily as it is given. Also, consent to the collection of personal data must be freely given, and it will not be sufficient to assume consent based on continuing usage. You must ensure that you are able to comply with the rights of data subjects. These include the right to access, the right of the data to be deleted, and the right of the data portability. For example, if personal data is commonly held in an email system or manual filing system, it would be onerous to meet the rights of data subject, and its organization should consider changing such practices. It would also help with compliance if you hold data only for as long as it is required for a specific purpose, and after which it should be securely deleted. You need to decide if data protection impact assessment will be needed, and whether you will need to appoint a DPO, a data protection officer. Security of personal data is a key principle of the GDPR and needs to be based on an assessment of the risk to the data subject of that data being compromised. There is a lot to think about, but if a structured analytical approach is taken to identifying gaps, it is possible to produce a prioritized plan of action towards compliance, and equally importantly, providing evidence of compliance. The GDPR states that the data controller must implement appropriate technical and organizational measures to ensure and to be able to demonstrate that processing is performed in accordance with the regulation. Even if you are not able to comply by May 2018, a gap analysis and a plan to compliance provides evidence in the intention towards compliance. GDPR affects all organizations and all businesses collecting personal data, however large or small. We at Pinhorn Associates provide a GDPR service tailored for SMEs that is intended to make the journey to compliance as quick and simple as possible by providing a gap analysis and prioritize for action plus simple spreadsheets tool that can be used as the basis for planning to full compliance. The cost is low and enables you to focus on your business with the confidence that GDPR compliance is being addressed.